Hey everyone, welcome back to another episode of Captain Hunter's podcast. Thank you so much for tuning in. Thank you so much for taking this ride along with me and with us. If you listened to the last episode, then you know that we are expanding Captain Hunter's podcast. We're going to talk about more than just police work. We're going to get into talking about you, life coaching. As I mentioned in the previous episode, I am actually a life coach, and there's some other certifications that I'm also working on in order to make my business more palatable and more well-rounded and other things like that. So I want to be able to offer you as the listener and as the customer, potentially, a host and list of ideas. I want to be a resource for you to come to for a number of different things, not just when you want to hear about police stuff or law enforcement issues, but I want you to come to me for a number of other things as well. And we'll get into that at a later time. So yes, I am actually a certified life coach. So if you're looking for a life coach, or someone else who is in need of a life coach or needs to get on track or get their thoughts together, I can actually help you out with those things. So just something for you all to keep in mind. But yes, we are going to continue to bridge the gap between the police and the communities that they serve. I think it's very important. But as I mentioned before, right, so we can't just build up the police. We can't just always look at the police or law enforcement. We have to look at ourselves, and we have to look at the community. And that's what we're going to continue to do. We're going to be well-rounded in this podcast as far as looking at the police, what they can do better, and looking at the community and what they can do better. And we're going to start with you as the individual, and we're going to expand from there to you as the individual, to making you a better you, so that way you can be a better parent, better father, better husband, better spouse, and so that you can be a better member of the community, a better member of your family, better member of your church, your religious organization, your civic organization, etc., etc., etc. So that's what's going to be going on with Captain Hunter's podcast. So please make sure that you tune in, make sure that you rate these episodes, that you subscribe, and that you share. So if you want to hear more, if you know someone else who's looking for more than just a law enforcement based podcast, they're looking for that type of self-help, get up and go, life coaching type of stuff, take a listen to Captain Hunter's podcast, because he's going to be presenting new ideas and new formulas to help to make you a better you, right? So that's what it's all about, and that's what we got going on over here. So on today's episode, we got a great episode. I have an attorney, Jonathon Smith. We're going to speak to him, and I'm really, really looking forward to the conversation. We had a great conversation, as I do so many times when I have a conversation with someone. What I usually do is I will call them up and we have a start dialoguing just a little bit, just to get my guest relaxed, just so I can relax a little bit, because believe it or not, I actually still get a little nervous when I start interview sessions. So we kind of just feel each other out, have a great conversation. And Mr. Smith and I, conversation was so good that I had to hit the record button just to get in on it, because he really was given a lot of good history and a lot of good facts on what we got going on. So I really think that you're going to enjoy the conversation with Mr. Jonathon Smith. So let me read Mr. Smith's bio to you. Jonathon M. Smith was appointed Executive Director of the Washington Lawyers Committee for Civil Rights and Urban Affairs in July 1st, 2016. Immediately prior to joining the committee, Mr. Smith was the Associate Dean of Experimental and Clinical Programs of the University of the District of Columbia David A. Clark School of Law. Mr. Smith was the Chief of the Special Litigation Special Rights Division of the U.S. Department of Justice from 2010 to 2015. The section was responsible for pattern or practice investigations of civil rights violations by law enforcement, correctional, juvenile justice, and mental health and developmental disability agencies. Under his leadership, the section conducted the civil investigation of the Ferguson, Missouri Police Department following the death of Michael Brown. Prior to his governmental services, Mr. Smith was the Executive Director of the Legal Aid Society of the District of Columbia Public Justice Center in Baltimore, Maryland, and the D.C. Prisoners Legal Services Project. In each of these positions, in addition to providing program leadership, he has handled individual, class action, and impact litigation, engaged in legislative advocacy, and in institutional reform efforts. He started his career as an associate to Virginia civil rights lawyer Victor Glassberg. He's got a few publications. How I came across Attorney Smith is because I came across an article that was written and then republished. The name of the article is "Across the U.S., Police Contracts Shield Officers from Scrutiny and Discipline." This is from Reuters.com where I'm reading this. This was published originally in 2017. And then if you listen to my previous episode concerning do black officers need their own organizations, in my interview with Damon K. Jones, who is the president of Blacks in Law Enforcement of America, the BLEAUSA.org. And once again, that article appeared there. And so what I did was I read through the article talking about police contracts. And as I read through the article, obviously Mr. Smith was mentioned in the article, which I highly want people to go and check out. And as he was in this article, I reached out to Mr. Smith, Attorney Smith, and he was so kind enough to be on the episode. So that's how I met up with him. And he's doing great work as far as civil liberties, equal justice. So that's Mr. Smith. That's what he's doing. He's an attorney out of the Washington area. He works for the Washington Lawyers Committee for Civil Rights and Urban Affairs. So without further ado, ladies and gentlemen, here is the interview with Jonathon M. Smith, attorney at law. It certainly is my pleasure. Since retiring, thought a lot about this, and I think that these conversations certainly need to stay alive and that we can't let them go away. And I certainly appreciate the work that you've done regarding this topic and other topics as well. I was reading over some of your other articles. Fascinating stuff, especially the one I read about the Terry v. Ohio. I got to figure out the name of that. There was Terry v. Ohio. You talked about the 3 laws that really kind of govern how police uses of force. Terry v.
Yes.
Yeah. That was really fascinating. And I had
well, thank you.
I had another professor on. He was kind of trying to explain a lot to me too, and it really got into it a little legalese, and I didn't really understand what he was saying. But I certainly appreciated what you were saying. I was able to follow it and all that, so it was really fascinating.
Oh, good. Yeah. Lawyers don't try to explain things in language anybody can understand, to kind of keep it within the club. And some of these areas, particularly around things like stops, searches, and seizures, are getting more complicated as the courts struggle with them, and so it's the fact that people sometimes get confused is not a surprise.
Yeah.
I think sometimes the courts are confused by what they're trying to accomplish.
Yeah, what fascinates me about that. I know we're kind of getting off topic here, and we'll get into what we.
No.
What fascinates me about that is I think the history of the United States. Now, I don't know how much you know about other countries, but I did an episode on other countries. And I kind of dug into how policing is done in other countries, their training. Mm-hmm. And is this whole stop and frisk thing that goes on in the United States, is that really subject to or an outgrowth of the slave catcher type of scenarios? And as you addressed in your article, that a lot of this stuff really didn't come into play until the Kerner Commission to the 1960s, right? This whole stop and frisk question. In other words, police for centuries were just able to go up to people and just do whatever. It wasn't until the protests and riots and everything that they really had to take a look and see what is going on and how much can the government intrude upon people's freedom.
No, I think that's right. I mean, one of the things that's sort of interesting about the Terry case, which I think a lot of people don't read the case all the way through and don't read it very carefully, and certainly the way the courts interpret it today, they don't, is that the court in Terry was very conscious of sort of the implications of on sort of human dignity and on sort of your independence and freedom for the police to be able to stop you without reason. And so they were trying to, a lot of the courts now want to expand the circumstances in which police can stop someone and lower the bar as to what justification is needed. In Terry, they were actually trying to put guardrails around people's liberty to make sure that it was protected. And it is sort of stunning. I think that had you had it, that this case come down at a different moment in time, you may have had a different result, but it really was a product of the fact that you had people in the street that were protesting around what police were doing, and this they recognized that the police were just walking into particularly communities of color. They actually talked about the implications on communities of color in that case, who walk into communities of color, and people had no rights to be free from police interfering with their liberty. And that was what the court was trying to accomplish. It's not held as tightly as I think the court had hoped, but it is an important part of what that decision was trying to achieve.
What do you think the reason is for the courts in particular to go away from that? I mean, is it because we live under the threat of terrorism? Why are the courts going away from that?
I don't think so. I actually think that it has got to do with the demonization of people of color through the war on crime and the war on drugs. And I think that I think that's what happened. You had Jim Crow, as you pointed out. There's a long history of police being formed and having as one of their primary functions to return escaped slaves to the South. But you don't need to go back that far. I mean, you look at what, the whole Jim Crow period and the role that police played in Jim Crow. One of the things that I always find sort of interesting is that you look at 1967 when you had the disturbances in cities across the country, kind of as an inflection point in this country's history, where it was in many ways coming to the end of a certain form of Jim Crow. And the rebellions in those cities, I think, woke up, a lot of America and a lot of the court system to the racial implications of the way that our criminal legal system, not just police, police get the brunt of the blame, but you got to look at the way courts operate and prosecutors, and you read it, you read any of this history, and it's a system that and it's not just the front line of that system that functions this way. But in 1968, when the Kerner Commission report came out, you had about 200,000 people in prisons and jails across the United States, and most of those people were white.
Right.
And the reason was that you didn't need prison and jail, or the white power structure didn't need prison and jail to impose social control over the black community. Direct violence against people of color by police and others was the method by which social control was maintained. After Kerner and some of the reforms that came after Kerner and the civil rights movement, Richard Nixon started the war on crime, and the war on crime sort of had several reasons. For political reasons, he needed an enemy, and it was just as he didn't have a foreign enemy to rally his supporters around, so he created a domestic enemy, and that domestic enemy, first the war on crime and then became the war on drugs, was really code word for a war against the largely urban African American community. And that's why you see this huge shift in our prisons from going from mostly white to mostly African American, because the kind of violence that was directly imposed upon people of color became violence that had to be under the color of the legal system. And so you institutionalize that violence through arrest, prosecution, first criminalization of activity. We saw this explosion of laws that criminalized a lot of behavior and then imposed longer penalties. And beginning in the 70s, really through the mid-1990s, this explosion of just passing more and more punitive statutes and criminalizing more behavior and imposing longer sentences. And so that the social control over the black community, particularly the urban black community, really came through the operation of the court system and had this patina of due process attached to it. And so the extrajudicial terrorism of Jim Crow became legalized terrorism through our legal system. And that, I think, is I don't know how I got off on this tangent. You asked me a question. I'm sorry, but I think that's where a lot of this came, and so that's why when you see cases like Terry, they came in a moment in time when you saw the courts really beginning to struggle with the issue of at the end of Jim Crow, and where we had this legalization of, we were trying to place limits on the official power so that people's liberty could be protected, even the liberty of people of color. It was really an interesting moment in time. And so then the system, as elastic as it is, just responded by just putting this sort of institutionalizing what ended up being a very violent system that ended up, locking up now, millions and millions of mostly young African American men.
Exactly. So from the end of the Civil War, we get Reconstruction. Then the end of Reconstruction, we get all this time of legalized brutality against Black people. The courts then wrestle with this in the 1960s, and then and so now that this power is taken away, and so now that brutality that you mentioned is now just transformed to more legal brutality. So is it really that? And when I say things like every social problem that the United States faces really has some racial animus to it, racial history to it. Am I wrong in that? Right? We look at abortion, we look at the immigration debate. You name the social issue. Where is race not involved in that?
Right. I think that's right. I think and even if you look at struggles that are not directly related to race, around gender or LGBT status, around disability, the way in which discrimination plays out is always racialized. The difference in the experience of discrimination of a white woman and a woman of color is just different. The difference in the experience of a person of color who has a disability and a white person with a disability is just profoundly different. And you look at LGBT youth and the difference between African American or Latinx LGBT youth and white LGBT youth is just a really different experience. So even struggles that are not directly about race are racialized in this country. It's really frightening.
It definitely is. It definitely is. So we kind of got in here talking about something completely fascinating, but just tell the audience just a little bit about yourself and how you became a civil rights attorney.
Sure. I'm the executive director of the Washington Lawyers Committee for Civil Rights and Urban Affairs. We're a nonprofit civil rights law firm here in the District of Columbia. We operate mostly in the District of Columbia, Maryland, and Virginia, although we have some cases all over the country. And our work focuses on looking at the way that primarily around racial inequity, but across several domains. We do a lot of work with regard to housing and housing segregation, access to employment and jobs, and discrimination in access to the economy, disability rights, work around education, and a lot of work in the criminal justice area where we handle cases involving police misconduct, collateral consequences, discrimination against people who have criminal records in housing and employment, and prison conditions. And then we do a fair bit of work on behalf of African American and Latinx police officers in our criminal justice practice who are subjected to discrimination inside their police departments. I've been doing work regarding reform of the criminal legal system since the early 1980s. I graduated in 1984 from the Antioch School of Law here in the District of Columbia and joined a small civil rights practice in Northern Virginia with a terrific lawyer named Victor Glassberg. And we did a lot of prison and jail work. And after 5 years with Vic, I helped start a program to represent District of Columbia prisoners here in D.C. called D.C. Prisons Legal Services Project. Since then, in a variety of different capacities, I have done anti-poverty and civil rights work in the nonprofit sector that I did spend 5 years working as the chief of the special litigation section in the Civil Rights Division of the Department of Justice during the Obama administration from 2010 through 2015. And in our section, we were responsible for the work to reform police departments across the country, work on juvenile justice and the conditions of juvenile incarceration and cases involving prisons and jails across the United States. So I had the real honor to work with a terrific team of lawyers on a whole range of cases, about 20 of which involved police departments. The first case I worked on was the New Orleans Police Department, and the last was the Ferguson, Missouri Police Department.
Okay. And so you go to law school, and how did you get, I assume from law school that you kind of have to choose which path you want to go. You become a divorce lawyer, you become a criminal attorney, a civil rights.
Sure.
Yeah.
Sure. I had always wanted to use my law degree for the purposes of social change. I went to law school because I had a strong view that if I had the privilege to be a lawyer, that I wanted to use that privilege to make the world a better place. I had been an activist in college, had wanted to do, work that, so across a broad range of work. I grew up in Maine. Maine is not a terribly diverse place. It is.
I have a friend who lives there now. I have a black friend who lives there now. I'm like, why are you there?
Yeah. I knew one black family growing up, several native families, but it was largely an entirely white culture. And I lived in a rural place. And I showed up in Washington, D.C., and it was an extraordinary experience. One of the great things when I went to Antioch School of Law, which they don't do anymore, but what they did back then, is you spent the first several weeks of your law school experience living with a client family. And so I ended up on North Capitol Street in D.C. at a time when North Capitol Street was a very different place, and developed a tremendous relationship with a family and community, and I understood rural poverty, and I understood rural poverty in the context of, at least to some degree, in the context of sort of a mono race kind of culture. And I understood, and what I came to understand in those few weeks is how little I understood about the racism in our country and the legacy of racism in our country. It certainly wasn't taught in our schools. I certainly wasn't exposed to it growing up. And that set of issues was just, the injustices I saw from that moment forward were just, made a profound impact on my desire to try to make a difference. I was able to work at the firm I ultimately ended up working at after law school, beginning in my second semester of law school as a student law clerk. And I spent a summer interviewing prisoners in the Alexandria City Jail, which was then in a dilapidated old building, which was about 200 years old and originally built as a poorhouse. And fell in love with the idea that through the law, I certainly couldn't, abolish the prison or reduce the prison, but through the law, we were able to close that horrible place and make sure that the conditions in which people were confined going forward were within the limits of the Constitution. And that led me to really, sort of see the intersection between poverty, race, and the way our criminal legal system functioned, and have always felt just compelled to work in that space.
Nice. Well, thank you for all of your work.
Thank you.
So we started off with a very fascinating conversation about the history of policing and the decisions, the court decisions, Terry v. Ohio, Tennessee versus Garner, Graham v. Connor, all that kind of stuff. And so and the reason I wanted to have you on is because of a piece that I saw that you were mentioned in. I saw it first in an organization called Black Law Enforcement in the United States, their website. The name of the article was Across the U.S., Police Contracts Shield Officers from Scrutiny and Discipline. I think the same article is also in Reuters.com. So you were mentioned in it, and I wanted to talk about that. So we talked about the history of policing and the attempts to make change. And I think that the U.S. Supreme Court did struggle with that change in Terry v. Ohio in the 1960s. We had the Kerner Commission and all these different commissions since. And so, but what has been fascinating is at that point in time, continue till today, the resistance from police unions.
Right.
And I wanted to really have a discussion about that.
Sure.
You and I obviously think that some reforms need to take place. When we look at, and some reforms have taken place, body cameras and more, an attempt in some places of more transparency. But there's always this resistance. And I wanted to really discuss this resistance, why that is.
Sure.
How can we stop it? I am a former police officer. I appreciated my union. I mean, I didn't get into trouble, but the few times that if I had a car accident, which I had a couple of, it was always the union that came to my defense. So I'm not trying to bash any union. So any officers out there who think I want to get rid of unions, you're absolutely wrong. But I want to make sure that unions do what they're supposed to do. And that's, protect the organization and protect the integrity of good officers. And so many times these lines get blurred, darn near crossed, to where they're standing up for bad officers. And this is hurting law enforcement, the reputation across the board.
Yeah, I completely agree. I mean, I am a strong believer in unions and labor movement, and I think that they do play a critically important role, in all workplaces, and including in policing. So, I do have concerns about the way contracts have been written and negotiated, and candidly concerns about whether leadership in unions represent their rank and file in a way, and it's certainly not my role. Rank and file get to choose their leaders, but I have to say I've spent a lot of time talking to individual police officers in jurisdictions all across the country, and it is not uncommon for me, in my experience, when you get develop a bit of a relationship with a line officer, for them to tell you, look, I am afraid on the street because there are some bad officers in the department, and what they do reflects on the entire uniform. And people can't tell the difference between, when they look at the uniform, whether it's me or the guy that's going to treat them with brutality. And it's really important to me, to each of these officers, we'll say it's really important that we not protect officers who shouldn't be on the force. It makes the job harder, more dangerous, and what have you. But there's a real gap between that sentiment often and the way that a union will fight, to preserve officers on the force who might really ought to be doing something else. And so it is a concern that the unions sometimes take positions in individual cases and candidly take positions with regard to reform efforts that don't serve their members, and may not even reflect the views of their members. And it does get in the way of creating a workplace for officers that is safer, where when they put on that gun and the badge in the morning, and I firmly believe that most officers do it for all the right reasons, that they do that in a way that they can go and they can feel satisfied in their job and not feel like they're always either under attack or afraid. And these reforms that we have pushed and the kinds of change that can be brought in policing, I think really will make the job for officers a better job, one that people will feel better about and be more effective at.
I want to stress the point that you made, that officers are telling you, and correct me if I'm wrong, officers are telling you that they want more accountability. They want the police unions to back down in certain instances because they understand that it's hurting the reputation of the police department when bad apples, as it were, stay on the job, get promoted, whatever. They officers are telling you this. So that's telling me, and should be telling the audience, that there are good officers out there who want change and reform and want to have the badge respected and be professional.
That's right. I've heard from more than one officer in more than one department that they believe that their ability to do their job effectively and their satisfaction in their job and their safety is placed at risk because there are people who are protected to remain on the force who shouldn't be there.
Right.
And, it is also, I think about some of the ways in which the reform process, when you look at what's gone on in jurisdictions where there's been consent decrees or where there's been community demands for reform, we think about the way in which, accountability may bring more trust between police and communities. And I think that that's an incredibly important thing. There's a lot of ways in which trust can be built. But there are other innovations that, if you look at the consent decree and the reform process, that I think, officers are getting some things that they had wanted for a very long period of time. And the reform can be a real tool to achieve that. When you think about, for example, the fact that as a culture, or as a government, we have failed to invest in other strategies to address people with mental illness, and that police officers, you talk to officers today, and 15 years ago, they might have encountered someone on the street with mental illness that they had to interact with a few times a month. And probably today, officers are encountering people on the street a few times a day that are in crisis or are struggling with mental illness. And it is a real challenge. That's not a law enforcement problem in the main, but because we haven't invested in any of the resources, law enforcement officers are called upon to deal with these very, very difficult situations. And if you look at places where there has been consent decrees, where there's been a reform process, and some of this, you've seen unions fight, but has really improved the life of officers through both providing them with additional training so that they can be more effective in those situations and they can be safer in those situations and they can deliver services more safely, but also bringing other resources to bear. I think about Portland, Oregon as an example, where you had a series of officer-involved shootings that had ended in deaths of people in crisis. And after both additional training was put into place, but also that officers got additional non-law enforcement resources to assist them to deal with people in crisis. In other words, to make the police officers not the sole and only person who was involved and that other resources brought to bear. You saw that there was a dramatic decrease in the number of officer-involved shootings and dramatic decreases in the number of times that officers felt, whether those shootings were lawful or not, where officers felt like they had, placed themselves in a situation or were in a situation where their physical safety was such that they had to use their weapon. And that is a real benefit to officers. We often think about the consequence, and we should be thinking about the consequence of the civilian when the civilian gets shot. But I've talked to officers after they've been involved in a shooting, and it has a profound harm to them as well when they feel that they need to pull their weapon and shoot. And so, by bringing through this reform, by bringing the reform process and achieving those kinds of changes, we can actually make that day-to-day experience of officers better and more effective. And it is often very frustrating when every effort to try to address these kinds of issues is met with resistance from organized labor.
Yeah.
The bigger...
Go ahead. I'm sorry.
I was saying, I don't want to get away from the point that you made earlier, though. The bigger problem in many cases is that there's a real struggle with unions around the structures of accountability, that through collective bargaining, we've moved away from, in many ways, creating the kind of accountability structures that are designed to both get at the truth and to address any problems as they emerged, and have become overly formalistic and technical, so that it makes it much harder for a police department to be able to either identify an officer who needs some corrective behavior and that they correct corrective action. And that doesn't always have to be discipline. I think that that's an important thing to remember, is that, if you can identify early on that someone has a problem, you can often save a career before there's something more serious happens. And that can happen through corrective behavior that is not punitive. That might be additional training, that might be counseling, that might be partnering, that might be changing a job assignment. And that it makes it much harder where you've got, when misconduct does occur, where it is much harder to address that misconduct. And, in cases where officers should be removed from the force, more difficult to remove from the force, not because someone's rights have been violated, not because the officer's rights have been violated, but because there's so many technical requirements and barriers to actually achieving the kind of change that you hear chiefs time and time again talk about how we know who the officers in their force that are there that are problematic. They know who the officers on the force that are going to create the next, incident that's going to make it to the front page of the newspaper. They know who is going to use excessive force, but they can't do anything about it because they missed the deadline, or the Civil Service Commission refused to act, or some other barrier, even though the facts are known and the public safety is at risk by not having been able to address the underlying problem.
Right. You mentioned consent decrees, and I did my very first episode was on consent decrees, and it was the audio was so terrible I ended up taking it down, so I can't even listen to it anymore. So what I was very shocked at is the amount of consent decrees that have gone on around the country: L.A., Chicago, Baltimore, Cleveland, Newark. You mentioned Portland, and also not only the police departments, but sheriff's offices, some correctional facilities. I did not realize how pervasive this problem is, in which people were treating other people poorly. That really has shocked me. I don't know if you can speak to that at all, but just the amount of people, amount of agencies who have this mindset that it's okay to trample on the rights of other people. It really is shocking to me anyway.
Yeah. There are 18,000 or so police departments in the United States, although, some half or more of them are fewer than 50 officers. And so, only a small number of the police departments in the nation actually are under some form of court supervision. That said, some of the very largest agencies in the country either are under consent decree or there's a court-ordered injunction on at least part of what they do. I mean, New York City, on stop and frisk, there's some 20 consent decrees that were entered into during the last administration in police departments, across the country. There's private litigation that, Sacramento, there's, in Oakland, and there's private litigation in Maricopa County, and the Department of Justice ultimately joined. There are some very important, significant departments that are under consent decree. One of the things, being in the Department of Justice, that I found, and one of the things I think was most important that we ended up doing during the last 5 years, certainly the cases we brought and the problems we solved inside jurisdictions were critical. But we also were able to document in an important way what was going on in policing in this country through by the time the administration ended, I think there were 24 or 25 investigations of police departments across the country that had been completed. And they ranged from very small departments like Ferguson, Missouri, and East Haven, Connecticut, with around 50 to 60 officers, to very, very large departments like Chicago, Baltimore, Puerto Rico, and departments in between, in Seattle, Albuquerque, and other places. And they were all across the country. They were in the Pacific Northwest and in the South, Miami. They were, in the Midwest in Cleveland, and just in Southwest and Phoenix. You saw it was in liberal cities and in conservative places. And what developed was a real picture of the fact that there is a crisis. Not crisis in the sense that it's sudden or emerging. It's been going on for a long time, but a crisis in terms of a problem of some urgency in policing across the country. And we decided early in the last administration to change one of the things we did. The statute we enforced was enacted in the wake of the disturbances in Los Angeles when the officers who beat Rodney King were acquitted by the state court in Simi Valley. And the federal prosecution was brought under a federal criminal law. But the United States had no civil authority to go in and try to reform a police department prior to 1992. And the statute was enacted in 92. And it had been in existence almost 20 years by the time, we started to really think hard about, is there a different approach to the way in which we would reform police departments? And one of the things we thought was very important was that we document what facts we found during our investigations and how we would apply that to the law. Previously, in prior administrations, there had been, a significant number of cases that have been brought. They were largely resolved fairly quietly with private settlement agreements between the United States and the jurisdiction. There were some famous consent decrees. LA was one, and some others. But most of the cases were private settlement agreements, and it was a relationship that existed between the federal government and the local jurisdiction. But we began to understand that if reform was really going to take, if there was going to be the political will to carry through, which is a very difficult and complicated project, that there needed to be community support and that the community needed to know what was going on. And it was essential that the community understand what, based upon our, factual investigation, which was very thorough. I mean, we spent thousands and thousands of lawyer hours, thousands of hours of police consultant time conducting these investigations, that people would understand what we found factually and would understand what we thought that the remedy would be, how it applied to the law, what we thought the remedy would be. And we issued these findings reports, which were quite detailed. And I think one of the most important things we did was those reports, because they documented, they gave a chronicle, if you look across this country, of what are the common themes that are happening in departments everywhere. And we found that there was, in every jurisdiction, it was different. There were different things happening. There are different ways that the issues manifest themselves. But in almost every jurisdiction, we found that there was a problem of lack of trust by the community, particularly communities most likely to be policed in the police department, that there were antiquated views about use of force and the way force should be used that didn't meet the standards of the Fourth Amendment, and that in most or all jurisdictions, there was at least a reason to be concerned about the relationship between police and communities of color, and whether there was bias that had become part of the policing process. And while it's important to understand the difference in each of these jurisdictions, it's also important to pull back the lens and see that this is not a problem unique to one city or one place or one location. This is a problem of national magnitude.
So let's get back to union contracts and trying to change this, right? Listen, I'm enjoying the conversation so far. And that consent decree, what you just mentioned, was certainly outstanding. And I just wonder why this is so pervasive. But one of the problems is with changing that, changing these different cultures. As you've mentioned, we needed to have the community support, but we also need police union support, police officer support, which we get individually as officers have come to you. But these union contracts are what's in many ways standing in the way. Now, for Reuters, or for this article that you were mentioned in, you gave a little bit of the history. Can you give a little bit of the history about how the union, which I thought was fascinating, about how the unions stopped getting money as incentives because the cities were crying poor. They couldn't give them money, so they gave power over discipline away. The cities gave the power of discipline away. Can you explain a little bit about that?
Yeah, I know. In the collective bargaining process, it varies a bit from state to state because these are public sector and they're not governed by the federal law, but they're governed by state laws. You bargain about the terms and conditions of employment, and typically that means things like, and there's a difference between what's bargainable and what is a management right. And typically, terms and conditions of employment are things like, what are the hours that you're working? How much money you're going to get paid? What does overtime look like? What's the schedule for vacations, and what's seniority and all that sort of stuff. And then there are a series of things which are typically considered to be management rights. Those are the kinds of things that go to the establishing the priorities of the organization and operating the policy side of the organization, and discipline is one of those things that falls somewhere in the middle, where the protection of the due process rights of police officers is critically important. You don't want to have an institution, a justice institution, where the people who work at an institution are treated unfairly. I mean, that kind of equitable treatment is critically important. But you also need to have it's a paramilitary organization, and you need to have the ability of the leaders of that organization to impose the kind of discipline necessary to ensure that the institution is functioning. And what you saw with the financial crisis beginning in the 1980s, with the recession during the time of Jimmy Carter, you saw a recession in cities and towns across the country. And then, it's continued later in the recession in the late 1990s, and again, really it was those two time periods. You saw both a explosion of organizing amongst police officers. There's some departments have been organized for a long time, but there was an increasing organizing effort during some of those time periods, and you saw the growth of the power of police unions, and the ability for police unions to change the laws about what they could bargain, and the introduction of law enforcement bills of rights. And then at the bargaining table, you saw cities that were unable to put money on the table. They were unable to say, we'll give you, you haven't had a raise in your wages for, 5 years or what have you, but we can't put money on the table, but we'll give you all of these other non-economic protections. And once they get into the contract, it's almost impossible to get them out. And so you end up with these very elaborate, very complicated kinds of discipline systems that are designed to prevent any discipline from being imposed. They create they're not only very complex, but they take a long time, and they've got lots of deadlines that are built into them that if they're, kind of a procedural default that doesn't really affect what the findings of the, kind of getting to the truth of the matter or what's an appropriate response to the truth of the matter, but is, some sort of technical, somebody didn't sign a form in the right box, somebody missed the deadline by a day. You end up not being able to impose discipline. And so, that is part of what happened, and the power of the unions to control the way in which officers were held accountable and to take that authority away from chiefs just became a real function of the union bargaining process, and one that I think is not served departments well, and I don't think it's actually served individual officers well. I'm sure that it's kept some officers on the force, but it has, I think, done great damage to the rest of the officers that have served without engaging in this conduct.
Yes, I don't think that it served the departments well either. I can remember, when we would go through something and the union would fight for the rights of someone who we thought was justifiably terminated. And here they are fighting for this. And we were looking around, scratching our heads like, what are you guys doing? This guy shouldn't be here. But they did what they had to do.
Right, no. Yeah. And we should have a process that gets to the truth. We should absolutely, officers ought to have the ability to make sure that any decision made about their career is based upon facts and the truth. And I completely think that that's an important procedural, equitable, process for officers, and that discipline should be proportional and, both proportional in fairness to the officer, but also designed to promote public safety. That's what I think we have lost sight of, is what the purpose of the discipline process is. It's now a game about trying to, can we find a way procedurally to defeat an effort to correct behavior, rather than what really happened here.
Right.
What happened on the street when something did something wrong? Was this officer really at fault? If this officer was, what's the right response? Is it more training? Does the officer not have adequate resources? Or was it something that the officer did, the officer knew that she or he shouldn't have done, and that some other form of discipline ought to be imposed. And we can't have that conversation in these processes now. They're so tied up in technical procedure and the opportunity for there to be some mistake that then kicks the discipline out altogether.
Right. So again, from this article, across the U.S., police contracts shield officers from scrutiny and discipline. There's a point in here, and they give about 4 bullet points. I'm going to read each one. I'd like for you to comment on them, if you would.
Sure.
Reuters, examining the fine print of 82 police contracts in large cities across the country, found a pattern of protections afforded the men and women in blue. First point, a majority of all the contracts call for departments to erase disciplinary records, some after just 6 months, making it difficult to fire officers with a history of abuses. In 18 cities, suspensions are erased in 3 years or less. In Anchorage, Alaska, suspensions, demotions, and disciplinary transfers are removed after 2 years.
Yes, this is a very serious problem, and you see it in many departments where, and it's a serious problem for a couple of reasons. In many departments, you'll see that after a certain period of time, a chief can no longer consider prior misconduct by a police officer, whether that's for the purposes of imposing discipline because there's been a new offense, or whether it's for the purposes of promotion, that officers with very serious discipline records, you can avoid any consequences after a few years of that discipline in a promotion process. And, I have heard chiefs complain that they are promoting people that they know shouldn't be in those positions because they're aware of this prior misconduct, but because of the union rules are not allowed to take it into account when making a promotion decision. It's also very problematic for a department who's trying to understand its own behavior and whether there are policy, training, or systems changes that ought to take place. And so, if you can't sort of track and measure your own behavior, because after 6 months or a year or 2 years, the records that describe that behavior and where problems might have emerged, you can't figure out whether or not you have a policy problem. You can't figure out whether or not you have a training problem. And so this data is actually incredibly important for, a thoughtful department administration who wants to say, how come over the last 10 years we've seen this change in pattern of behavior? Or we haven't seen a change in pattern of behavior, but the circumstances and conditions in the community have changed. And what are we doing right and what are we doing wrong? And by losing this information, it becomes much more difficult to engage in corrective action. But it is serious. If you have an officer who has a series of kind of discipline offenses, and that they're eliminated because of the passage of what is a relatively brief period of time, and then they're either back out on the street or they're promoted, and you can't take that into account in either their assignment or their promotion or in future discipline. It just sustains a real problem in the department for that officer's misconduct, but also morale for other officers who don't engage in misconduct.
I agree. The second point, and I don't really know why this is a point. I actually don't have a problem with this, but I read it anyway. Nearly half of all contracts allow officers accused of misconduct to access the entire investigative file, including witness statements, GPS readouts, photos, videos, and notes from the internal investigation before being interrogated.
So this is controversial, and I think this is a complicated point, because there's a tension here between interviewing an officer because you believe the officer engaged in misconduct and you want to talk to the officer before you make a decision about whether to charge them administratively or pursue criminal proceedings, and whether or not you're interviewing the officer for the purpose of trying to determine what happened in a particular incident and try to get to the sort of the bottom of a factual situation. And so if what you're trying to do is to get to the facts, you want the officer's unstudied recollection. You don't want the officer's recollection of what happened to be clouded by the fact that now he or she has read all this information. They may have viewed the body camera video. They might have, understood what their partner said about a particular incident. Because then when you interview them, there's simply their recollection is going to have been transformed by what they have read. And so I do think that there, for the purposes of, an investigation of an incident to kind of find the facts, having an officer sort of prepare in that way is not necessarily all that helpful. I think it ends up creating a kind of an echo chamber. For the purposes of due process, I completely agree that if an officer should not be, as any person accused of misconduct, you ought to know what you're confronting, and out of kind of fairness, you ought to have access to what the accusation is and what the evidence against you is. And so, I think from my way of thinking, it really depends on what the purpose of the interview is and when it's being conducted, and as to what you should allow an officer to view or to see. So I don't think officers should look at body cam videos before they write their reports, because I think it ends up, the body cam video gives you one perspective, and if you're just simply being informed by that one perspective, then you're going to miss what might be otherwise very important information the officer will fail to include.
Yeah, no, I can certainly see how this particular point can be go both ways. I don't mind. We didn't have body cameras, but I would not have minded looking back if my department had body cameras and the officer wanted to view it before. In fact, I probably think that was probably the best thing, because you want to make sure. But I having not been there.
This is one where I think the consensus is not yet resolved on what the right way to approach this is. I think there's very strong arguments on both sides,
right?
And people are of a different viewpoint. But I don't think that this shows. I don't think that this shows that there's some overreach by unions. I think this is This is
I agree.
I do think. Yeah, go ahead.
I was going to move on. I think we're going to move on from that. It's not there yet. So, 20 cities, including San Antonio's, allow officers accused of misconduct to forfeit sick leave or holiday and vacation time rather than serve suspensions. My own department allowed that too. So if you got 10 suspension for 10 days, they allowed you to burn 10 of your vacation days rather than. And the point of that was so you do not hurt their family, right? You want to implement some type of discipline, but you don't want to hurt their family. These people, now it's 2 weeks without pay. So you don't want to, that was the purpose and point of it. But what's your opinion about that?
I'm not sure I would use sick leave, but I think using annual leave is fine. And, and this is where a lot of my progressive friends disagree with me. I'm not a big punitive guy. I think accountability, is a very multidimensional kind of thing, and that this both individual accountability and department accountability are important. And so I think that we ought to be measured in punishment, and that every time an officer engages in misconduct, the department ought to ask the question: was that misconduct as a result of something of a failure of one of our systems? And is there an approach to fixing it that is beyond just punishing the individual officer? So I think that if it's proportional, sort of losing your vacation time is not nothing. I mean, that's paid time off that you're not able to take. So I think that's in many circumstances that's not necessarily inappropriate. I'm not sure getting paid sick time off for discipline actually is all that all that punitive. So I'm not sure I would do that, but it seems to me that being able to use your annual leave, is a punishment. And I also agree that it's not like officers are getting rich off of their job and they're doing a hard job, and to punish their families is a hardship. I do think that communities, the optics of that though are hard for communities. I think communities feel like that's an officer walking away without any consequence. And so, if the department can otherwise do the things necessary to create community trust, then that concern, I think, gets mitigated quite substantially. But, you do spend time with people who are in communities most likely to be policed, and they do feel like there's just never a consequence for officers. And I think that something like that probably contributes to that sense by the community.
Yeah, you're right. I would agree. The final point here from this particular article, then I want to move on to another point, is contracts in 17 cities set time limits for citizens to file complaints about police officers, some as short as 30 days. 9 cities restrict anonymous complaints from being investigated. In my department, we mandated any investigation, whether somebody just called in and just left a message, or if they sent an email and they never wanted to come in, never responded to any other further outreach, we still had to investigate. So how do you feel about that?
I think this is a huge problem. I think that the restricting departments from investigating any information they have of misconduct or problems by the conduct of a police officer is deeply, deeply problematic. There should not be limits on the way information can come to the department. I know, for example, lots of departments, if the person who makes the complaint doesn't sign it in person, they won't consider it. If they make one phone call and it's not returned by the person to try to get more information, then the case is not pursued. And I think that's really problematic. The department shouldn't care quite so much. It's not an adversarial process between the citizen making the complaint and the police officer. It's about whether or not was an issue or something that happened that the department ought to know about. And any information from any source that the department has ought to be pursued.
Yeah, I would agree.
So I think that's a real problem. And I think that if you make it hard for people to file complaints and they're afraid to file complaints, then it just shields a lot of conduct that otherwise should be addressed.
Now, let's talk about the shielding, or people are afraid of making complaints. Have you come across people who have complained and have been retaliated against, threatened, or whatever? When I was the head of the internal investigations unit of my department for a while, and I knew some people in the community who thought that if they made a complaint, all of a sudden now they're being stopped more by the police, or or they thought they were being followed by the police. I certainly don't believe that was happening in my department. We certainly did not give out orders like that. Anytime I was in patrol, there was no scuttlebutt about that. Is that an issue in some departments?
It is, and I've heard that a lot from people in the community. I think it's extremely difficult to establish. Just because of trying to create a kind of a factual record that would allow you to show that the reason why something happened to somebody was a result of their civilian complaint. But that's a widespread belief that you put a target on your back when you file a civilian complaint. I've heard that concern, from a lot of people. And the more onerous the process, the more likely it is that people are going to have that concern.
Right. So I wanted to talk about this last point here, and this is about civilian review boards and how they would help out with the police union contracts. And I read this article in the New Yorker. It's called Why Are Police Unions Blocking Reform? And just a little bit about this. I'll just read this a few sentences from this. And we talked about some of these points already, but I want to concentrate on the last point about civilian review boards. For the past 50 years, police unions have done their best to block policing reforms of all kinds. In the 70s, they opposed officers wearing name tags. More recently, they've opposed the use of body cameras and have protested proposals to document racial profiling and to track excessive force complaints. They have lobbied to keep disciplinary records history sealed. If a doctor commits malpractice, it's a matter of public record. But in much of the country, a police officer's use of excessive force is not. Across the nation, unions have led the battle to limit the power of civilian review boards, generally arguing that civilians are in no position to judge the split-second decisions that police officers have to make. How do you feel about that?
So I think that civilian oversight is critically important. I think it should not just be limited to discipline, but there should be civilian engagement around the priorities and policies of departments. And, I'm not suggesting that you have a civilian agency run the department, but that there be input from communities. I think about some of the work we did, again, around prisons in mental health crisis and getting both people living with mental illness as well as mental health providers to help the departments write their policy is a good example of how you can have productive citizen engagement. You can reach out to communities around your use of force policy. You can reach out to communities around other policies. You can have transparency in your data around stops, etc. But I do think that we've come to expect that there will be a role for civilians in the most serious discipline in most places across the country, and that there'll be an independent civilian body to engage in those investigations. It has always been my view, candidly, that in a really good internal affairs does a better job often than a civilian body can do. But I think there is a value in community trust in having some form of civilian oversight and involved in that process. The data that is pretty, at best, mixed about whether a civilian body is more punitive or harsher than the internal affairs process. I know that they just went through this in Los Angeles County, and they went from a system where you had a committee that was made up of some command staff and then had a civilian representative, and there was a voting analysis that was done, and the civilian was actually less likely to impose discipline in those cases than the command staff members of that committee were. Wow. Almost across the board. Wow. And so I think that there's this perception that civilians are going to be punitive, but I think in reality, it doesn't play out that way. And that you'll very often see, certainly maybe in some of these high profile, kind of cases that make it the front page of the papers, you may see sort of a harsh response from a citizen body, but in the main, they're not as punitive as an internal affairs process might be. And so I think that it's interesting that unions have kind of taken this position. I think they actually do better in front of civilian groups than they do in front of the internal affairs, because the command staff knows that if they leave the officer in the force, they're going to be in one of their they're going to be working for them somewhere, and there's an incentive for an internal affairs process to ferret out the officers that are most troubling. If it's a good internal affairs, I mean, as you know, that's uneven. There are lots of departments that do a terrific job of internal affairs, and a lot of departments where internal affairs doesn't function. And so it, in some ways, I'm on this whole question about civilian involvement and discipline, I'm kind of agnostic. I think that it can work, but I think departments ought to be owning their own accountability. It's better for departments to own their accountability. And I also think that civilians can play a much more important role in influencing the development of policy and training and the priorities of the department. So I'm something of an outlier. I think in most people who are reformers really think that particularly in the serious cases, taking it out of the chain of command and giving it to an independent civilian body is going to be more effective. I think the evidence is not clear on that. I think optically it's important. I think giving the confidence in the community is important. Whether it's more effective, I'm just not sure.
And that's very surprising to hear about LA County, because I read a story about them in the LA Times about their sheriff's department. I'm not trying to pick on any department, but I guess they had some problems with police gangs, minor groups and gangs within their police department.
Well, they used to, and this is LAPD, not the sheriff.
Oh, okay.
So, but it was just also, I mean, you may remember, the Ramparts scandal opened up a lot of information after it was investigated back in the 1990s, late 1990s. They found that there were, and I think there's still some of this in LA sheriffs, but in LAPD, you had specialized units. They had their own symbols. People got tattoos. They really operated with all of the trappings of that you would think of as a street gang, and it was deeply problematic. I'm sure some of those problems can continue to exist, but it was really quite eye opening in the 90s when, after the investigation of the department revealed, huge, kind of issues that were very gang-like. The sheriff's office is an interesting place because its leadership ended up in jail. So,
jeez. Yeah. Wow.
It was, you had both the sheriff and the deputy sheriff ended up being charged criminally. There's still some struggles going on as a result of, what was that, 5 years ago?
Yeah. Well, this article I read was, I read it last month or so I don't know how old.
Yeah, no, it could be. I think that's a department. I think the sheriff's department is a department that is struggling.
Yeah. So it seems. So thank you so much. I don't want to hold any more of your time. So I just want to say thank you again. I want to give you a chance to talk about whatever you got going on and what we can do as a community to help being more engaged, to make our police departments better. And if you got any books coming up, any articles or whatever you got going on.
Okay. Well, thank you. No, I'm not known for being optimistic, but in this area, I actually am. I had, last week I was in Fort Worth, just coincidentally for a conference on policing. It was with the judges and monitors and lawyers that are handling consent decree cases, and had a chance to talk to some of the community members in the wake of the horrible shooting that happened down there. And, the thing that gives me some hope is that you do have people throughout the community that remain paying attention to this issue. Now, we've got, the last couple of years, we've had this kind of crazy news cycle with, at the federal level, a presidential tweet will push everything off the front page. And we're no longer seeing the conversation that, we had in the few years prior to that about what we think public safety is and how to achieve it, and how communities and law enforcement can work together to co-produce public safety. But that's happening at a community level, and people are organizing around it. And while I think we have a long way to go and there's real trouble, there's real problems to be solved, I also have a lot of optimism. There's a lot of people both that are outside departments and inside departments that really want to have a different conversation and really do believe in public safety and really do believe that public safety is going to come from a relationship between policing and communities that's really different. And so I think we've got a lot of work to do. We'll continue to be in that struggle, but I also think that there's reason to be hopeful.
Very good. Thank you so much. All
right, thank you.
Attorney Jonathon Smith, thank you so much for being on the podcast.
Thank you for having me.
Okay, take care. We'll talk to you.
Take care. Bye-bye.
Once again, I want to say thank you to my special guest, Attorney Jonathon M. Smith. Thank you for being on the podcast. Very enlightening conversation. I did learn a lot, and I hope that you as a listener also learned a lot. Please make sure that you rate, subscribe, and share. Remember that you can help to support the podcast through Venmo, through Cash App, through PayPal. All of those are cptlhunter, at cptlhunter, $CPTLHunter, Lawrence Hunter / cptlhunter. That is on PayPal. Remember, I am on Twitter, cptlhunter, Instagram, cptlhunter. Also, remember, we got a Facebook page. Go on over to Captain Hunter's podcast on Facebook. We're going to start some discussions, and we're going to have a lot going on Captain Hunter podcast to discuss a lot of things that are going on in the community and in your local police department and how we can make everything better. And also remember, we're going to make you better, right? With the life coaching and life business and podcasts that we got going on once again at Captain Hunter's podcast. So thank you so much for tuning in. Until next time, ladies and gentlemen, much love and peace. Bye.